Welcome back to our weekly case discussion. For our next case, let me ask you some questions first. What if you heard a terrible accident, but never actually saw it? And the shock from that moment caused such severe trauma that you lost your unborn child. Could you sue the person who caused the accident? That heartbreaking question reached the House of Lords in Bourhill v. Young, 1943. A case that shows how far the law of negligence will go and where it draws the line. The facts. Mrs. Bourhill was a pregnant fish seller who had just stepped off a tram. At the same time, a motorcyclist, Mr. Young, was riding through nearby streets when he collided with a car at an intersection. Mrs. Bourhill did not witness the crash itself, because the tram she had just exited blocked her view. However, she heard the collision. After the tram moved away, she walked towards the scene of the accident. When she arrived, she saw the aftermath, including blood on the road. The experience caused her severe emotional shock, and she later suffered a miscarriage. Mrs. Bourhill brought a negligence claim against Mr. Young's estate, arguing that his careless driving had caused her psychiatric injury. The legal issue. The court had to decide. Did Mr. Young owe Mrs. Bourhill a duty of care for the psychiatric harm she suffered after hearing the accident? More specifically, the judges considered whether the harm she suffered was reasonably foreseeable. Decision. The House of Lords held that Mr. Young did not owe Mrs. Bourhill a duty of care. Her claim therefore failed. The reasoning. The court explained that liability in negligence depends heavily on reasonable foreseeability. For a duty of care to exist, the claimant must fall within the range of people who could reasonably be expected to be affected by the defendant's actions. In this case, Mrs. Bourhill was considered outside that range because she was not in the immediate area of danger. She did not directly witness the collision. Mr. Young could not reasonably foresee that someone in her position would suffer psychiatric harm. Although the injury she suffered was tragic, the law requires that the claimant must be within the zone of foreseeable harm. Because she was not, no duty of care was owed. Legal principle. The case established an important limitation in negligence law. A defendant is only liable to people who are reasonably foreseeable victims of their actions. If someone is too remote from the accident, the law will not impose liability for psychiatric harm. Why this case matters? This case helps define the limits of the neighbor principle established in Donahue v. Stevenson. While that case expanded negligence law, Bourhill v. Young shows that the principle has boundaries. Not everyone affected by an accident can claim compensation, only those within the scope of reasonable foreseeability. Let's do a quick case summary. Case: Bourhill v. Young, 1943. Area: Tort law, negligence. Mrs. Bourhill heard a motorcycle accident but did not see it. She later suffered severe shock and miscarried. She sued the motorcyclist's estate. Held: no duty of care. Rule: liability only arises for reasonably foreseeable victims. Next case in the series. But what happens when someone does witness a traumatic accident and suffers psychiatric harm? And when does the law recognize them as a secondary victim? That's exactly what the courts explored in the landmark case of Alcock v. Chief Constable of South Yorkshire Police, arising from the Hillsborough disaster. In the next episode on Friday, we will break down why some relatives of the victims could not claim compensation for psychiatric injury, even after watching the disaster unfold on television. See you next week. Thanks for listening.